federal constitution is the country's highest law, which went into effect in 1957. The federation is established as a constitutional monarchy with the Yang di-Pertuan Agong as the head of state, with mostly ceremonial functions. It forms and organizes three main branches of the government. Firstly, the bicameral legislative branch, known as Parliament, which is made up of the House of Representatives and the Senate. Next is the executive branch, headed by the Prime Minister and his cabinet ministers. And lastly, the judicial branch led by the Federal Court. One of the characteristics under Federal Constitution is the fundamental liberties, which consist of the rights of us as human beings. The fundamental liberties are laid out in Article 5 to 13 of the Constitution. Article 5. This article states the few basic human rights, such as no one should be deprived from life or personal liberty unless with the interference of law. Other than that, the High Court should release anyone that are unlawfully detained. Next, a person has the rights to know the reason behind arresting and may have a lawyer of their choice. Lastly, a person cannot be arrested more than 24 hours without the magistrate's permission. Article 6. This article states that no person should be kept in slavery. No form of slavery allowed, however. The federal laws such as the National Service Act 1952 may create laws that require some Malaysians to provide compulsory services. However, the services from someone that is convicted for a crime is not considered forced labor. Article 7. This article states that there should be no retrospective criminal laws or increase in punishment and no repetition of criminal trials. Some of the protections stated under this article are no one should be punished for the crime that they have done that are not punishable by the law. Other than that, no one should have to go through a heavier punishment other than what has been stated by the law. Lastly, a convicted person should not have to be tried again for the same offence unless ordered by the court for a retrial. Article 8. This article states that everyone are equal according to the law and have their own rights on equal protection, as stated by Clause 2. Except as expressly authorized by this Constitution, there shall be no discrimination against citizens on the ground only of religion, race, descent, gender, or place of birth in any law or in the appointment to any office or employment under a public authority or in the administration of any law relating to the acquisition, holding or disposition of property, or the establishing or carrying of any trade, business, profession, vocation, or employment. The affirmative steps taken to preserve the special status of the Malays of Peninsular Malaysia and the indigenous peoples of Sabah and Sarawak under Article 153 are among the exceptions specifically permitted by the Constitution.
Next, Article 9, which is the prohibition of banishment and freedom of movement. Based on the article, a Malaysian citizen cannot be expelled or barred from entering the country. In general, every citizen has the right to freely move and reside in any part of the country except where a law relating to the country's security, public order, public health, or the punishment of offenders has been passed. However, because of Sabah and Sarawak's unique position in comparison to other states, legislation can be enacted to regulate who can enter and remain in the two states. After that, Article 10, which is the freedom of speech, assembly, and association. Every citizen has the right to freedom of expression and speech. However, Parliament may pass laws restricting this right if it is necessary or expedient in the interest of the security of Malaysia, friendly relations with other countries, and public order or morality. The citizens also have the right to peacefully assemble and form associations without the use of weapons. Parliament can also make laws to restrict the right to form associations in relation to labour and education. Moving on to Article 11, freedom of religion. Every person has the right to profess and practice his own religion. They also have the right to spread their religion, but state law and in respect of the federal territories, federal law may control or prohibit the propagation of any religious doctrine or belief among Muslims. However, there is freedom to engage in missionary work among non-Muslims. Furthermore, Article 12 established the rights in the area of education. The provision states that no citizen shall be discriminated against solely on the basis of religion, race, ancestry, or place of birth in the administration of any educational institution maintained by a public authority and in particular the admission of students or the payment of fees. there should also be no discrimination in providing out of the funds of a public authority financial aid for the maintenance or education of pupils or students in any educational institution. Lastly, Article 13, which is rights to property, says that no one should be deprived of property save in accordance with law. No law may compel for the compulsory acquisition or use of property without providing adequate compensation.
A court hierarchy established which decisions are binding on which courts. There are some exceptions and complications to what follows. But, in general, and for most purposes, the higher up a court is in the hierarchy and the more authoritative its decisions. Authoritative is meant in the sense that a decision of the higher courts will bind lower courts to apply the same decided principle. The Malaysian legal system hierarchy is mainly centered despite Federal Constitution of Malaysia. This system is partially influenced by the British common law and the Islamic law to a lesser extent with no political interference from this influence. In Malaysian legal system hierarchy, there are usually two kinds of trial, namely civil and criminal, where its jurisdiction of courts they are that matters in Subordinate Courts Act 1948 and Courts of Judicature Act 1964. Malaysian legal system hierarchy consists of three courts: the superior courts, the subordinate courts, and the Sharia courts. The superior courts comprises the Malaysian High Court, the Court of Appeal, the Federal Court, and Court of Sabah in Sarawak. The subordinate court comprises the Session Court, the Penghulu Courts, Magistrate Courts, and Juvenile Courts. The Sharia Court have jurisdiction over the issues of Muslim and has an imprisonment term of not exceeding 3 years. Under subordinate courts, the state judiciary courts are well known to be under the system as it most involved in all cases not specially selected for federal courts but more on state level. The state judiciary consists of the high courts at the top of the hierarchy of subordinate. They are in subordination of the high courts. They work in the distinct and below, and the judges are appointed by governor with consultant with high court. The distinct and the session judge courts is the highest authority, and below is magistrate court and subordinate judges and municipal courts. Magistrates are divided into first class and second class magistrates, the former being legally qualified and having greater powers. Second class magistrates are normally appointed. A first class magistrate might hear a civil case when the amount is disputed does not exceed 100,000 ringgit. A first class magistrate might hear criminal matters of which following nature, where the offence is punishable by a fine only. This will be covered a majority of the traffic offences. All offences provide a term of imprisonment not exceeding 10 years. A first class magistrate may not impose a term of imprisonment exceeding 5 years, a fine exceeding 10,000 ringgit, whipping exceeding 12 stroke, or any sentence combining any the sentences above. Second class magistrate may hear a civil case where the plaintiff seeks to recover a debt or liquidated demand in money payable by the defendant, with or without interest may not exceeding 10,000 ringgit. Where the amount claimed does not exceed 5,000 ringgit, you may wish to file your claim in the small claim division of magistrate court. Second class magistrate may hear criminal matters of following natures, where the offences is punishable by fine only, where the offences provide a term of imprisonment not exceeding 12 months. A second class magistrate may pass a sentences a term of imprisonment not exceeding 6 months, a fine not exceeding 1,000 ringgit, or any sentences combining of the sentences above. A session courts may hear any civil matter involving motor vehicle accidents, dispute between landlord and tenant, and distress action. The session court may also hear other matters where the amount in dispute does not exceed 1 million ringgit. Session courts have jurisdiction on civil cases that claim does not exceed 1 million ringgit as per Section 65(1)(b), 73(b), 93(1) or Subordinate Court Act 1948. It is exceptional, however, that the session courts have unlimited jurisdiction pursuant to Section 65(1)(a) ACA in matter relating to motor vehicle accident, landlord and tenant, and distress. By virtue of a Section 65(3) ACA, the parties to a legal action may enter into an agreement in writing to grant jurisdiction to a session court to try an action beyond its prescribed monetary jurisdiction aforesaid. For criminal cases, on the other hand, the courts hear all criminal cases except one that are subject to death penalty. The Court for Children, previously known as the Juvenile Court, hear cases involving minors except cases carrying a death penalty. which are heard in high courts instead. Cases for children governed by the Child Act 2001. A child is defined as the person below age of the 18. In general, the special protection for child offenders under Child Act apply to all child offenders under age of 18, with some exception. If a child turns 18 while the proceedings are ongoing, the court for children must continue to hear the case. However, it is up to the discretion of the court whether it applies to the special sentencing provision available for children under the Child Act or imposes an adult term of imprisonment. If a child commits an offence while under 18 but turned 18 before being formally charged, then the trial is heard by the regular adult criminal courts. The court may choose to apply the special sentencing provision available for children under the Child Act or impose an adult term of imprisonment. If a child commits a crime together with an adult, the trial will be heard in the adult criminal court rather than a court for children. However, the court must exercise, in respect of the child, all the powers which may be exercised under this act by a court for children, and must consider a probation report before sentencing the child. The court for children does not have jurisdiction over children charged with an offence punishable with death. However, while the Child Act does not state so explicitly, the special protection for children relating to procedures for arrest, detention, trial, and sentencing should still apply equally, regardless of whether the case is before High Court rather than the Court for Children.
The High Court in Malaysia are the third highest court in the hierarchy of the court, and there are two chief judges in the High Court. Firstly, the first is in Peninsular Malaysia with contain 45 judges and judicial commissioner, and the second is in Sabah and Sarawak which has 11 judges and judicial commissioner. The High Court have general, supervisory and revisionary jurisdiction over all the subordinate courts, and here appears from the subordinate courts in civil and criminal matters, but generally confines itself to offences on which the magistrate and session courts have no jurisdiction. In criminal cases, no case may be brought to the High Court unless an offender has been committed for trial after hearing in a magistrate court. The jurisdiction for this court regards all civil matters including bankruptcy or winding up matters, probation and administration of the estates of deceased persons where the amount in dispute exceeds 250,000. The High Court has the jurisdiction to try these civil matters where the cause of action occurred within Malaysia, the defendant lives or has his business in Malaysia, the facts on which the action exist within Malaysia. The High Court may hear appeals from the magistrates and session court both in civil and criminal matters. In criminal jurisdiction, the High Court may hear all matters but generally confines itself to offence on which the magistrate and session courts have no jurisdiction. For instance, offences which carry the death penalty. The court in Malaysia are heading towards specialization. This move is fueled by the desire to provide the best service in the public in the form of dispensing justice fairly, speedily and effectively. In the High Court in Malaya at Kuala Lumpur, specialization is done by categorizing the High Court into Criminal Division, Appellate and Special Power Division, and Civil and Criminal Division. Under the Malaysian Federal Constitution, the states in Malaya and the Borneo states of Sabah Sarawak shall have one High Court each of coordinate jurisdiction and style the High Court of Malaya and the High Court of Sabah Sarawak. When the Federation was formed in 1963, each High Court was headed by a Chief Justice. The Chief Justice of Borneo State is based in Kuching. The title of Chief Justice were later changed to Chief Judges in 1994, and the High Court of Borneo to the High Court in Sabah and Sarawak. Under the Article 161 of the Federal Constitution, we can see as stated below one of the use of English and of native language in states of Sabah and Sarawak. Next, the Court of Appeal. The Court of Appeal is the second highest court in the hierarchy below the Federal Court. The court is headed by the President of the Court of Appeal and constitutes up to 10 Court of Appeal judges. Every proceeding in the Court of Appeal shall be heard and determined by 3 judges or such a great uneven number of judges. The Court of Appeal is an appellate court of the judiciary system in Malaysia and has jurisdiction to hear appeals against any high court decision relating to the criminal matters. In civil matters also, the Court of Appeal has jurisdiction to hear and determine. However, no appeal shall be brought to the Court of Appeal in the following cases. First, if the amount or value of the subject matter of the claim is less than 250,000, except with the leave of the court. Next, the judgment or order is made by consent of parties. Other than that, the judgment or order relates to the cause only. Lastly, where by virtue of any written law, the judgment or order of the High Court is final. The Court of Appeal has no power to review, reopen or rehear any appeal has been heard and disposed by the Court of Appeal. The Court of Appeal is the final Court of Appeal on matters decided by the High Court in its appellate or revisionary jurisdiction. The Federal Court. The Federal Court of Malaysia is the highest judicial authority and the final Court of Appeal in Malaysia. Its decision binds all the courts below. The Federal Court consists of a president style as the Chief Justice, formerly called the Lord President. Then the President of the Court of Appeal, 2 Chief Judges of the High Court in Malaya and Sabah Sarawak, and presently 6 court judges. The Federal Court is normally heard by 3 judges or such a greater uneven number of judges as the Chief Justice may determine in some particular cases. The Federal Court has the exclusive jurisdiction to determine: first, all civil and criminal appeals from the Court of Appeal. In civil appeal, a litigant may appeal on a point of law the rejection or admission of evidence in lower court. In criminal cases, an appeal may be made against acquittal or conviction or against sentence on a point of law or fact. Next, disputes on any other question between states or between the federal and any state. This is under Article 128(1) of the Federal Constitution. Other than that, any constitutional question which have arisen in the proceeding of the High Court but refer to the Federal for a decision. The Yang di-Pertuan Agong may refer to the Federal Court for its opinion any question as to the effect of any provision of this Constitution which has arisen or appears likely to arise, and the Federal Court shall pronounce it in open court its opinion on any question so they refer to it. The Sharia court system is one of the 2 separate systems of court which exist in Malaysia legal system. There is a parallel system of state Sharia court which has limited jurisdiction over matters of state Islamic law. The Sharia court have jurisdiction only over Muslim in the matters of family and religious observance and can generally only pass sentences of not more than 3 years imprisonment, a fine up to 5,000 and up to 6 strokes of cane. The Sharia courts duly constituted under any law in a state and invested with jurisdiction over person professing the religion of Islam and in respect of any of the matters enumerated in List 2 of the State List of the 9th Schedule to the Federal Constitution are hereby conferred jurisdiction in respect of offences against precepts of the religion of Islam by persons professing that religion which may be prescribed under any written law, provided that such jurisdiction shall not be exercised in respect of any offences punishable with imprisonment for a term exceeding 3 years or with any fine exceeding 5,000 ringgit or with whipping exceeding 6 strokes or with any combination of them.
For the legal profession related institutions and organizations in Malaysia, we have the Malaysian Bar and the Malaysian Legal Profession Qualifying Board. The Malaysian Bar is a professional body which regulates the profession of lawyers in Peninsular Malaysia. In Malaysia, there is no distinction between a barrister and a solicitor, and that it is a fused profession. Membership into the bar is automatic and mandatory. The bar was created under the Legal Profession Act 1976. Like other bar associations around the world, it has a wide range of functions, including to protect the reputation of legal profession, to uphold the cause of justice, to express its views on matters relating to legislations and others. One of the functions of Malaysian Legal Profession Qualifying Board is to decide on the qualifications which may entitle a person to become a qualified person within the meaning of Section 3 of the Act for purposes of admission as an advocate and solicitor in Malaysia. Qualified person meant in this context means any person who has passed the final examination leading to the degree of Bachelors of Law, is a barrister at law of England, or is in possession of such other qualifications as may by notification in the Gazette be declared by the board to be sufficient to make a person qualified person for the purposes of the Act. Here's a table of institutions and their recognized qualifications for entry into the legal profession in Malaysia. In this table, we can see there's University of Malaya, the Qualifying Board, International Islamic University, Universiti Kebangsaan Malaysia, Institute Teknologi Mara, Universiti Utara Malaysia, Multimedia University, University Sultan Zainal Abidin. Law degree holders from University Utara Malaysia are required to attend the training program on conveyancing practice, drafting pleadings and opinion writing conducted by the Bar Council Malaysia during their pupillage and obtain a certificate of completion. Meanwhile, law degree holders from Multimedia University from the intake session for 2009 to 2010 are required to attend the training program on conveyancing practice, drafting pleading and opinion writing conducted by the Bar Council Malaysia during their pupillage and obtain a certificate of completion. For further understanding of this topic, let's dive into the recognized qualifications in pursuing a legal profession in Malaysia. LLB is the abbreviation for Bachelors of Law, which is the professional law degree awarded after completing undergraduate education. CLP, the abbreviation for Certificate in Legal Practice, is a 9-month-long postgraduate course and examination taken by foreign law students and graduates of Bachelor of Jurisprudence from University of Malaya and Bachelor of Legal Studies from University Teknologi Mara to become a qualified lawyer in Malaysia. Advanced Diploma in Law provides you with the essential skills and competencies needed to excel in a legal career. This program would enhance the core foundations for a student intending to pursue advanced qualifications in legal studies. Next, let us move on to the global legal profession related organizations and institutions. International Bar Association (IBA) is the global voice of the legal profession. It is the foremost organization for international legal practitioners, bar associations, and law societies. The IBA has considerable expertise in providing assistance to the global legal community, and through its global membership, it influences the development of international law reforms and shapes the future of the legal profession throughout the world. This organization is born out of conviction that seeks an organization made up of the world's bar associations could contribute to global stability and peace through the administration of justice. The International Union of Lawyers, Union Internationale des Avocats (UIA), is the only major multilingual and multicultural international lawyers organization. The UIA is open to all the world's lawyers, both general practitioners and specialists. This organization works towards equipping members into having extensive legal expertise, which is reflected in high-level legal debates within its technical commissions and working groups, as well as in resolutions adopted regarding current problems faced by the legal profession throughout the world, and promote professional excellence in the UIA. The UIA offers seminars, training, sessions, and other events throughout the year around the world which qualify for continuing legal education (CLE) purposes. And this UIA is also committed to defending the cause of lawyers who may be pressured or threatened anywhere in the world through its lobbying and advocacy activities, and speak out against forces contrary to the proper functioning of the justice system and legally instituted bar associations. The UIA conducts its mission into a collegial atmosphere that favors friendship and good relationships between members.